Chase, Alex, what are some of the terms, like when working with a property tax consultant, that you'll hear when going through the process? Like some of the, the hearings and the names of those things. And then also, what are some of the expectations that somebody should have when they're either protesting or they're working with a consultant that's protesting for them?
Yeah, I mean, I think to talk about that, you kind of need to place it in context of how the process works. So there's a couple of different types of hearings that could happen. And ultimately what's going on is the county's publishing a value, and usually end of Q1, something like that, maybe May, maybe by May, somewhere around there. And then they're giving you an opportunity to quality control that value, basically, and say, I think this value is not correct, before they publish the tax bill on it. So that's what we're doing, is in that window there where we're quality controlling that value. And what we'll do is we'll file a protest, and then we'll talk with the county. And what we try to do first is we'll have what's called an informal hearing, where we're not going to go.
Keyword alert.
Yeah, that's right. That's where we basically talk directly with the appraisal district. In the formal hearing, it's the appraisal review board, which is supposedly a separate entity, making a determination between us and the appraisal district. But in the informal, we're just going straight to the appraisal district and saying, here's what I think the value should be. Do you agree? And we'll negotiate directly with them and try to resolve as many as we can that way, because it's simpler and faster.
Real quick, so you said the appraisal review board?
Yeah.
Who is that?
That's a panel of people appointed by a county judge to specifically sit and review cases where we in the appraisal district are not able to agree. Right? So we're going to try and resolve as many as we can in that informal process, because it's just a lot more casual. I mean, it's easier and faster.
Are you dealing with the ARB in the informal?
It's called informal for a reason.
That's right.
Yeah,
Are you dealing with the ARB in the informal?
No.
Or is it just appraisers?
Just the appraisers.
Yeah, okay.
Whatever we're not able to resolve amicably that way, and one thing to be clear is we're never just going to take the easy way out. That's not what that's for. That's for the low-hanging fruit. Clearly, this is what the value needs to be. We can both agree on that, right? For anything where we're at odds, we'll take that to the appraisal review board, and that's what's called the formal hearing. That's what we're guaranteed by tax code. And what we'll do is we prepare a case, and we have our turn to present that to the appraisal review board, which is usually a 3-member panel. And they'll listen to our evidence, they'll listen to the appraiser's evidence, and we'll go back and forth a little bit, and then they'll close the hearing and make a determination on what the value should be based on the preponderance of evidence presented. After that point, that is your final value for the year. Whatever they determine is going to be your final taxable value for the year. That'll get published on your tax bill. Unless we file an additional protest. If we go through that process and it seems like, for whatever reason, they weren't hearing our evidence the way that we think they should have, we think there's additional evidence here to be considered that didn't get the hearing we think it should have, we can file a further protest.
So you're saying if you don't get your way, and the client wasn't treated fairly, there's another option.
There's 2 options. There's a binding arbitration option, which essentially means you're presenting your case one more time to a completely independent arbitrator.
Hired by the state.
So they're not working for the appraisal district. They're not part of the appraisal review board. They are strictly third-party independent, looking at your evidence, looking at the appraisal district's evidence, and coming up with that true final value for you for the year. The other option is called litigation. It's also district court appeal, if you want to call it that. It's essentially a lawsuit. Yeah, it's essentially a lawsuit against the appraisal district. And that is a fairly lengthy process most of the time. I mean, it is a true lawsuit. It is filed in court. There's discovery evidence. There are certain motions that have to be filed back and forth.
We talked earlier about getting a target on your back. Can you get a target on your back for suing the county?
No, again, the county, they just don't have time to hold grudges. They have a lot of work to do. They're not just going to accept a reduction necessarily if you file a litigation. They're still going to present their evidence, and there's going to be back and forth. But it's another method that's above and beyond just the normal protest process.
key clarification there is you get to pick one of those two. You know, if you file for binding arbitration after your review board hearing, that's it. The arbitrator is deciding your final value for the year, and there is no further recourse. If you file binding arbitration, you can't file litigation, and vice versa. If you file litigation, whatever the judge determines, if there's a settlement, whatever that is, that's your final value for the year, and there is no further recourse.
Is there a certain type of property or type of client that you prefer to do a binding arbitration versus a litigation?
Yeah, binding arbitration has certain set of fees based on the property type, based on if it has a homestead exemption, and based on the value. And so we would push, if you're a single family property owner, you want to do a binding arbitration on your residence. That's the way to go. You don't want to do a litigation because it gets costly and it takes a very long time. So we are always pushing arbitrations for single family owners. On the flip side of that, if you're a commercial property owner and you're over $5 million in value, you don't even have the option to do a binding arbitration. You have to go straight to litigation. And keep in mind the filing fees on this and the attorney's fees, it could get costly. So it's cost prohibitive up front. You need to have a high value situation to go to a litigation to make it worth the cost.
And we analyze ahead of time. We think this makes dollars and cents to litigate, to put this money up front, and we make sure we don't do it on properties we're not very confident in, right?
Right.
Okay.
Yeah, we will. We want to let you know the expectations up front when we discuss that arbitration or litigation with you and what makes the most sense. We have a lot of clients that will get their value, their ARV value, and say, "I'm not happy with this. I want to sue the county." And we say, "Okay, there's a better option.
Here's what that means."
Here's what that means for you, but here's a better option. Here's the route we can go. We have more success maybe in this county doing this route. We usually have to set those expectations for the client and give them the better option for them. They might not know about it.
Just to be clear, like arbitration is not free either. If you want to file binding arbitration, you mentioned there's a deposit you have to pay, and it's a couple $100. And if
on the low end.
On the low end, that's right. It scales up from there. I think the minimum buy-in is like $450. So the way that works is if the arbitrator decides $1 closer to your value than the appraisal district's, if it's pretty much whoever's value he is numerically closer to, you get most of your deposit refunded back to you. But if he's numerically closer to the appraisal district's value, you lose your entire deposit. So you got to make sure that threshold is worth it, right? That you're not just throwing a Hail Mary trying to see if you can get it lower, because you could end up just losing money on it.
Yeah, there are times to bluff and times not to bluff.
This is not one.
Binding arbitration or litigation is not the time to bluff.
That's right. So, I mean, hypothetically, you could get a lower value and still lose money because it didn't meet that threshold where you get your deposit refunded back to you. So you got to make sure we don't steer everybody toward arbitration. We're actually very selective about who we recommend going to arbitration, and we try to be pretty choosy about that out of the best interest for our client. Maybe you didn't get the right value in your appraisal review board hearing, but it might not meet the threshold to where it's worth it to go to arbitration.
And we do have tons of experience with both.
That's right.
So we know what to expect in each county and what is the right route to go for that property owner in that specific area.
Yeah, I'd say we do a large number of arbitrations every year, but it's still something like only 1% of cases.
Right.
It's very few in terms of an overall percentage.